Hello and welcome to episode 45 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
I'm Christine Van Geyn, the CCF's litigation director.
And I'm Joanna Baron, executive director of the CCF.
Today, we're going to be discussing whether the right to freedom of expression protects naturalized gardens from busybody neighbors and bureaucrats.
I'll explain why Justice Jamal has agreed to recuse himself from Quebec's secularism law Bill 21 case, if that case comes before the Supreme Court of Canada.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to tell you about a brewing constitutional crisis. Well, it's really an update on something we've talked about before, related to the notwithstanding clause. So, Joanna and Christine, as you know, I just got back from Ottawa, and I was telling you about how it's just such a mess, especially in Byward Market. And, you know, I've lived in big cities. I've lived in Vancouver. I live in Toronto now. I've spent time in Edmonton and Montreal this year. And I think Ottawa now tops the list for the most, drug addicted and homeless people living on the streets. And it's just a brutal situation there. And one of the topics that came up on this trip, which was a work trip, was whether a new conservative government led by Pierre Poilievre would be able to fix this problem of, massive homelessness and street disorder. And there's a lot of concern that he won't be able to. And part of that is because court rulings might get in the way. And I was thinking about this, one of the big problems exacerbating this homelessness crisis is that there's a huge number of asylum seekers now. It was 150,000 last year, which is up from about 25,000 a decade ago. And a lot of these people are clearly living on the streets. You can see that with your eyes in Ottawa. And part of the reason for that is judge-made law has made it difficult for Canada to turn away people even from very safe countries like, France or Mexico, which is not entirely safe, but has huge parts that are quite safe. Another problem is that, a lot of people who used to be in jail are now out on the streets because judge-made laws made it harder to keep criminals locked up. And of course, there's the fentanyl crisis, which is a huge factor in this. And we've seen judges recently in BC say that, public use of fentanyl can't be banned because that could violate the rights of drug addicts somehow. And, these are the kinds of problems that might lead a new conservative government to consider using Section 33, the notwithstanding clause. And Poilievre has famously already said he'll consider using it in relation to crime. And we've discussed before that, Section 33 is a very powerful tool, and some people see it as illegitimate because in their view it's always overriding rights. Others see it as Parliament getting the last word on rights for 5 years at a time, so temporarily getting the last word. Whatever your view is on the notwithstanding clause, it does look increasingly like the Senate is now considering blocking Pierre Poilievre in using it at all, which would be a pretty big constitutional crisis. So the reason I'm talking about this now is Peter Harder, who was Justin Trudeau's on Justin Trudeau's transition team, and he served as the Liberal representative in the Senate before the senators were made independent, said in May that he moved actually a motion in the Senate that says, quote, that the Senate expressed the view that it should not adopt any bill that contains a declaration pursuant to Section 33. So, in other words, he wants the Senate to consider blocking all uses of the notwithstanding clause. And that seems like a pretty big problem constitutionally. So we talked about this on the podcast before, but what's new is that Paul Wells, who I think is the greatest political journalist in the country, got Harder to answer some pretty important questions about what he's talking about here and what he thinks the Senate should actually do. So that's what I'm basing today's headline on. Harder basically now claims that his motion, which would block any use of the notwithstanding clause, is just a starting point for discussion. And the interview gives some really interesting clues about where Harder's head is at. So he says, for example, that, quote, the use of the notwithstanding clause ought not be normalized in the federal parliament as it has, unfortunately, in some provinces. And it's not entirely clear what provinces he means because only Quebec has really used it more than 3 times. And that's a well-known fact because they didn't really accept the Constitution Act 1982. And Ontario has invoked it 3 times, and that's probably what he's talking about here. They did it once when a lower court blocked Doug Ford's cut to the size of Toronto City Council, once when the Ford government imposed contracts on education staff to keep schools open right after COVID-19 had just ended.
Although they repealed that immediately.
Yeah, they repealed that immediately. And once to extend limits on third-party advertising from unions. So this one's still working its way through the courts. And basically, there had been a 6-month limit on advertising before elections, and they extended it to 12 months, which a judge decided was an unconstitutional place to draw the line. So Harder notes that Section 33 was only begrudgingly accepted by the federal government as a compromise to be used sparingly, which is true, but that doesn't change the fact that it's part of the Constitution. And the really important thing Wells asked was about the Salisbury Convention, which is the basic idea that since senators are not elected, they're appointed, they have no business refusing to vote in favor of bills that the House of Commons has passed. They can study bills, they can debate them, they can propose amendments the first time the bills come before them, but they shouldn't be blocking any democratically approved bills, right? And Wells suggests that by blocking any use of the notwithstanding clause, they would be violating this convention. And Harder told Wells he doesn't think that that's true, which I don't really understand. Harder also says that the use of the notwithstanding clause involves a profound circumscribing of charter rights, especially if used preemptively because it's an admission of infringement of said rights. And as protector of rights, and especially as protector of minority voices, the Senate is best equipped and indeed obligated to push back in overt circumstances of tyranny of the majority. And this is interesting because, while I do think preemptive use of Section 33 is more concerning than using it after a court decision, I'm not sure I understand the reasoning that it's an admission of violating rights, because, the other way of looking at it is that it's a disagreement about the extent of rights. And Harder also seems to be suggesting here that the House of Commons can never be trusted to determine the extent of rights, but that judges and senators, somehow always can be. And it's true that senators and judges are appointed to age 75, and so they don't have to be reelected. And that may put them in a better position to protect minority rights. But I also think it's a little bit arrogant to suggest that use of Section 33 would always be tyranny of the majority. So Wells also asked whether, Trudeau put him up to this, and unsurprisingly, he said no. He asked whether the Senate would be a way for Liberals to, quote, govern from the political grave. Harder obviously said no to that. And then Harder explained that part of the purpose behind his motion is to develop criteria that senators could use, including asking whether the use is preemptive, or whether it's in response to a decision at the highest level, i.e. he seems to think it should go to the Supreme Court before it's used. Has there been a charter statement? Has there been consultation? Has time allocation been used? And Harder added that, quote, the Senate should be prepared to exercise its constitutional duty by continuing to make legislation better through amendments, but ultimately acquiescing to the elected House. This is with the caveat that the elected House isn't passing legislation that is admittedly violating the Constitution using the notwithstanding clause. So it's a really useful interview because it pretty clearly shows Poilievre will be in for a fight if he uses the notwithstanding clause, especially if he uses it preemptively rather than waiting for a case to go all the way up to the Supreme Court, which can take many, many years. And this would be a constitutional crisis because it's in a strictly formalist sense, the Senate can block any bill it wants, but with the Salisbury Convention, which is also part of our Constitution, it would be a very big deal to ignore it in these kinds of cases, which Harder seems willing to do. Howard Anglin and Ray Pennings have written about this, and they point out this isn't the first such crisis. In 1990, for example, then Liberal opposition leader Jean Chrétien suggested he would use the Senate to kill PC Prime Minister Brian Mulroney's GST bill, And Mulroney was able to get around this by appointing 8 new senators, which gave the Conservatives a 2-vote majority. But that wouldn't work this time because the Senate is at least 3/4 Liberal appointees already, and a PM can only add 8 senators at a time. So they'll just never have a majority. Like if Poilievre's elected, it'll be a Liberal appointed majority for the whole, a couple of terms at least. And Pennings and Anglin also point out there was a GST drama. So just 2 years before the free trade, or there was also a free trade drama. So just before the GST issue, the Liberal Senate actually blocked Mulroney's free trade bill, which required him to call an election, which forced the Senate to back down. But, that's not a solution that you can use very often. So anyway, good for Wells for getting this interview, because it really does confirm that we're headed for some sort of constitutional crisis if Poilievre takes over and tries to use the notwithstanding clause. Joanna, what do you think?
Yeah, this is super interesting. I have several thoughts. First of all, abolish the Senate. It's not clear to me.
That was going to be my take.
Yeah, well, you can talk about that. I'm not actually sure if I'm on team abolish the Senate, but Senator Harder should know that he can just be wiped out if he makes himself too much of a problem. The second thought I had, though, is this sounds very American to me, right? The whole notion of the Senate acting as a backstop. In the U.S., you frequently have like a Republican majority in the Senate and a Democratic majority in Congress. And so this whole notion that partisan considerations are sort of acting as a limit on powers in the different houses of government seems very American to me, and it's very much not in keeping with our tradition. But it does seem to me that if Harder starts to do this, and if he convinces other colleagues in the Senate to do this, the result will be politicization of the Senate. My understanding of the role of the Senate, I'm not an expert in Westminster-style democracy, but I did go to elementary school in Canada, is that the Senate is supposed to be like the sober second look. It's supposed to be less partisan. It's supposed to have more of an air of, dignified study of bills. And this just sounds brazenly partisan to me. I'm sure that Senator Harder would deny this, and he would say this is based on his conviction about, the merits of the notwithstanding clause. But it's certainly not happening in a vacuum that he's bringing this up in the context of there being this liberal apparatchik panic over how Poilievre is going to use the notwithstanding clause. And I'm sorry, but it seems brazenly like the Liberals see the writing on the wall. I mean, we're getting a bit more political than we usually do on this podcast, but they know that they're headed for a profound electoral defeat, and setting the stage for something like this, where they'll still, as you mentioned, have stronger footing in the Senate, is setting the stage for like curbing what they see to be damage control. So I may have made that sound more sexy and salacious than it's likely to be being Canada. But I think the real risk is that is undermining the legitimacy of Senate in the long run. What do you think, Christine?
I don't think the Senate has legitimacy. Like you were taught it was the sober second thought. My perception of the Senate since I was in elementary school in Canada was that it was where how you rewarded partisan hacks.
I will say that I've testified before the Senate a few times, and I've been really impressed by the seriousness and diligence and balanced nature of the questions that I've gotten. That's just my direct experience. Like Senator Paula Simons was a long-term journalist. She's very serious on free expression. You get questions that cut across partisan lines. So that's just my.
Yeah, I mean, I've heard this defense of the Senate many times. I've heard that their committees are better, that they ask better questions. I've heard, in the Emergencies Act case that there's a lot of people who make this claim that it was the Senate who wasn't going to confirm the declaration of the emergency, which is what resulted in Trudeau, ending the state of emergency. I don't know if I believe that. I don't know. I have no idea. But, there's all these, every once in a while, there's this circulation of how the Senate is actually really good. And it's kind of one of those thou protest too much things. Like we all acknowledge how stupid the Senate is. and how useless it is, and how it's just a place where you send old partisan hacks to reward them for a lifetime of service. And now here they're trying to come in and preempt. They're mad about the idea that Poilievre might issue preemptive declarations of Section 33, which, by the way, Poilievre has not said he would do. His proposal about using Section 33 is not about preemptive use. It's about reactive use to cases like Bissonnette, which found that long prison sentences without parole eligibility would violate Section 12 of the Charter, and he objects to that ruling, and he would want to use Section 33 to react. But they're kind of suggesting he has said he wants to use it preemptively, which he hasn't, and so they're saying we preemptively will block him. Like this is crazy. This just like it completely affirms my belief that the Senate is terrible and it's undemocratic, and that it's not even a lot of them. Like, yes, maybe some of them are smart people, but they're mostly not. It's mostly people that I don't have a lot of regard for. So, I'm pro abolish the Senate, except that I understand that would entail, probably opening the Constitution, having a constitutional convention, which will overall be probably bad because, they'll want to put all kinds of things in that I don't agree with. But I'm pro undermining the legitimacy of the Senate. So maybe if this undermines the legitimacy of the Senate, that is overall good, but I guess that's what you would call an accelerationist.
Yeah, I was gonna say. Now you're getting it.
Anyway, let's move on to. I'm not an accelerationist, for the record, but
you're a Senate accelerationist.
Maybe,
Yeah.
maybe. Okay, let's talk about my news headline, which is like a lot lighter topic, but it's something I've been tracking for a really long time. It's sort of like a pet issue that I have. It's the issue of gardens and freedom of expression. And I've done a few videos about this in the past. I've talked about this before. These cases where cities and municipalities want to mow down or have mowed down what are referred to as naturalized gardens. And naturalized gardens are when a garden is transformed from a traditional cultivated landscape, like a lawn of grass and rows of rows of roses and hydrangeas, that's transformed into a more natural landscape that mimics, like a naturally occurring habitat, like a meadow or a forest or a wetland, and it features native plants. And some people call this rewilding their garden or naturalizing their garden. And naturalized gardens can, I think, be a political and social statement. I have a neighbor who has a naturalized garden. She views it as, in her words, an anti-colonial project and an ecological and environmental project. Naturalized gardens use less water. They allow for the flourishing of plants that naturally come in our environment in North America. It rejects foreign imported cultivars. That's sort of part of the anti-colonial view. It views our environment, our habitats as worthy of celebration. And a great example of that is growing goldenrod or milkweed, which for a long time had been listed by some municipalities and still is listed by some municipalities as an undesirable weed, even though goldenrod and milkweed are actually pollinator plants that butterflies use as food and to and their pollinator plants are really excellent native plants with flowers, by the way, that can be beautiful. So the designation of those plants as a weed, meanwhile, invasive super spreader species like English ivy or periwinkle, those are not considered weeds and they're sold in garden centers. And I mean, listing goldenrod and milkweed as a weed and those other things as a good desirable plant, that's crazy to me. So naturalized gardens create a habitat as well for small animals like chipmunks, squirrels, rabbits, groundhogs, skunks. Maybe those are less desirable for some people like me with dogs. It creates habitats for birds, and so that's the case for naturalized gardens, and the case for that this is an aesthetic as well as a political, social, cultural statement. The case against them is mostly aesthetic. Like some people think that they are ugly because they can look like an unkept garden. It can be wild and unruly. And then there's another case against naturalized gardens, which is a safety issue, pest control, and that there's weed control issues. So there are some noxious weeds that are, bad and dangerous, like hogweed or poison ivy. There's the argument that these can create habitats for pests like rats or things. But I mean, that case is kind of silly because you can make that same case about a forest or any natural park that exists in our city. And then the other argument, I think probably this perhaps stronger argument, is that when these naturalized gardens are at an intersection, it can impede sight lines for traffic or pedestrians. So I guess, maybe it's a reasonable limit to say you have to cut the sight line so that, children won't get hit by cars or cars won't run into each other if there's a garden at an intersection. But only to the extent that it relates to the sight line. So it could mean just shorter plants, but not, raising the entire garden, which is what some municipalities demand. There are some municipalities that crack down on these naturalized gardens. They have tall grass and weed ordinances, or they have nuisance bylaws against tall grass and weeds. They send out bylaw enforcement on the basis of complaints by neighbors. Bylaw doesn't generally know the difference between desirable plants and the undesirable version of that native plant. So they will sometimes order the mowing of an entire naturalized garden, or they will just do it themselves. They will mow your garden and then send you a bill for it later. And this is a problem for a few reasons. Some weed ordinances don't actually define what a weed is with a sufficient clarity, or they improperly include pollinator plants like milkweed and goldenrod, which, ironically, some of these same municipalities then go on to plant milkweed and goldenrod in their own, cultivated butterfly habitat gardens that they have at schools and things like that. Another problem, and this is sort of the part that interests me, is that this could engage our Constitution. There's a claim that these ordinances and the enforcement of these ordinances is a violation of the right to freedom of expression. And I took a course on gardening at George Brown College a few years ago, where my gardening instructor told me about this. He said, "Oh, this is an expressive issue." And I was really skeptical. I didn't think like planting milkweed was an expressive act. But as the course progressed, I felt like that was a really ignorant thing that I believed, because garden design is obviously an art form. We give awards for garden designs. In England in particular, the colonial master of our gardens, who's now oppressing us by banning our native gardens. In England, garden design is like a real cultural phenomenon. It's a real art form. And I think it's an art form here as well. Naturalized gardens are also a political statement. An ecological view is being expressed. And the fact that some people may object to the aesthetic of a naturalized garden doesn't actually undermine the expressive protection. It's been said many times that it's minority or unpopular viewpoints that are worthy of protection. No one is disputing English rose gardens. They're fighting against the rewilding gardens because it's different. And The Guardian recently ran a story about a case of a Mississauga man named Wolf Ruck, who had his garden, faced enforcement in Mississauga. And of course, it was a British newspaper that ran a story about a Mississauga man. And it was King Charles, who's actually one of the biggest advocates of naturalized gardens. I mean, I don't like the monarchy generally. I'm not a fan of Charles in particular, but I agree with his sentiments about naturalized gardens. So Ruck took his case to court, and there is some precedent to support naturalized gardening as an expressive form. There's a 1996 ruling involving a woman named Sandy Bell and her right to express her environmental beliefs through gardening. And this, unfortunately, Ruck's case in Mississauga was not successful. He's self-represented and he lost his case. He argued that the weed and tall grass ordinances were ultra vires and unconstitutional for violating his 2B rights. and he argued that it was arbitrarily enacted and arbitrarily enforced, and that for reasons of biodiversity and climate change, he should be allowed to grow his garden wild. But the court found that while his garden was expressive, that the mowing of it would violate his constitutional right to expression, that it was a justified limit. And the court found that the bylaw was minimally impairing, and that the weeds that were prohibited in Mississauga were specifically listed for specific purposes as noxious weeds. Although I will note that Ruck disputed the listing of some of these weeds as noxious because he had a medicinal version of it. This again goes back to the ability of bylaw to actually enforce these laws given their lack of knowledge. And then the other weed, he said he just removed. So there isn't really a justification, in my opinion, for this being minimally impairing to mow down the entire garden when he removed the weed at issue. So they also found that the benefits of the bylaw outweighed his right to grow his garden. So he has expressed a desire to appeal. I think he's seeking a stay order as well. These are really interesting cases to me. There have been a number of them recently. I'm not sure what the record looks like in his case, so that might impact the appeal. But I'm going to track it. So Josh, I'll start with you. Naturalized gardens, whose side are you on? Is this a expressive right, or do you side with the Rose Garden Karens who are complaining about wolf?
Yeah, I'm on the side of freedom, obviously, liberty to plant what you want. Like, I think you should be able to do what you want on your own property, with the exception of, genuine nuisances. So I could see some cases where there's some like extremely noxious weed that genuinely just takes over and spreads extremely quickly and is a real menace and has to be controlled. But in general, I don't think the excuse
So
is
periwinkle?
no, definitely not periwinkle.
But that is a super spreading plant. Anyway, I won't interrupt. I'll stop talking about
No,
plants.
I agree. I think you're right. I think it's expressive, and I think these bylaws are a problem, and they're just, yet another example of us having stupid laws on the books that we don't really need and aren't justified and just are, minor forms of tyranny. So I'm really interested in this issue too, and I'm glad that you're reading through the case law and trying to figure it all out. So, Joanna, what do you think?
I'm very, very torn. So, of course, I think it's expressive. And, as the daughter of a naturopath, I'm extremely sympathetic to the idea that, like, plants are healing and we need rewilding, like I would say spiritually. On the other hand, I really think if that's really your bag, like living amongst wild plants, like maybe like go live in the country, like living in the city of Toronto is
You're
not
such a colonialist.
I'm sorry. I just like
it's from all the time you spent in England, in the Rose
Yeah.
Gardens.
Yeah, I guess so. Yeah, I believe in ordered liberty, I would say. So I would just say that. But yes, the restrictions should not be arbitrary. However, I'm very skeptical that there's going to be much uptake in the courts for this, because this is something that requires very specific expertise, like which weeds are going to spread, which are super spreaders, which might be poisonous, which might be a risk for sightlines. Like, this is all stuff that I'm sorry, but like, I'm not in favor of deference to the deep state, but I do think regulators will have much more expertise on this than judges. So yes, I think it's expressive, but we are literally getting into the weeds here in terms of So yeah, I'm not as bullish on this as you, Christine.
So, okay, that's it. Why don't we take a break now, and then we'll turn to Joanna's headline.
Okay, so we have some late breaking news out of Quebec and the Supreme Court of Canada. So last week, or I actually think it was last month, but this was reported on earlier this week, the Justice Minister of Quebec, Joanna Baron, asked the Supreme Court judge, Mahmoud Jamad, to recuse himself from the possible future hearing of HAC, which is the appeal of a challenge to Quebec's secularism law, Bill 21. And he asked Jamal to recuse himself, alleging that he does not have the judicial impartiality required to hear this case. And Bill 21 requires Quebec state employees who are in positions of authority, and this includes teachers, from wearing what is called ostentatious religious symbols like hijabs, Jewish skull caps, Sikh turbans, or Christian crosses, which just usually don't seem to be quite as ostentatious or visible while they're on the job. And the root of the allegation that Jamal would not be impartial enough to hear this case was that Jamal was previously president of the Canadian Civil Liberties Association, which challenged this law from the outset. And the allegation is that as president of the CCLA, Judge Jamal was necessarily involved in some way to the preparation of its claim against Bill 21, whether in drafting, revision, or simply to approve its content. And in a letter to the court, the Justice Minister of Quebec also said that Judge Jamal must decide questions of constitutional law raised by the association at the time when he presided of it. Means that he would be the judge of a case in which he was also a party. So we know that Justice Jamal and the court on Justice Jamal's behalf, denied this. So the Canadian press obtained a letter dated June 25th, which indicated that the court had no intention to ask Jamal to step down. And it said that he considered there is no real or reasonably perceptible conflict of interest that would prompt him to recuse himself. So that was the position, and this sort of hit the headlines a few days ago. And there was some flurry of discussion about the extent to which his involvement, whether there was a possible perception of a reasonable apprehension of bias. I'll get into the difference between subjective and perceptive bias. But in any event, we got the news last night that Justice Jamal has voluntarily decided to recuse himself from the hearing of the case. He still doesn't admit that he has any actual bias or perceived bias. But the statement that we got last night was that he doesn't want to be a source of distraction. Some people have speculated that this decision has something to do with the Chief Justice Wagnall, who is from Quebec and has been described as being very sensitive to all matters concerning Quebec. But there's two things to say about this. First, I actually went back and looked at a case that I remember we studied in law school that had a different outcome from this that is perhaps of interest. So this was a case called the Wakeham Indian Band. It's a Supreme Court case from 2002. And in that case, there was a claim that the band was bringing. I don't know exactly what the claim was. It's not really what the case ended up being about. It was about a Campbell River claim. And Justice Binney, who was then on the Supreme Court, had back in, I think, the late 80s been a senior advisor in the Department of Justice. And he had been involved in the band's claim in the 80s as the Federal Associate Deputy Minister of Justice. So the band claimed that there was bias, there was perceived bias. And the court ended up saying he's good. First of all, there was no subjective bias, meaning he himself, Binney testified that he had no recollection of being involved in this file at all. It never crossed his desk. And the court also found that there was no objective perception of bias, that just because he was justice minister and he also had a longstanding interest in matters involving First Nations, that was not sufficient to justify his disqualification. Now, you could say that Justice Jamal certainly didn't give evidence that he didn't remember anything about Bill 21. It was a signature piece of litigation for the CCLA from the outset when they challenged it. So maybe he couldn't make the same arm's length claim as Justice Binney could. But it also seems like there's just a real desire in this case to not rock the boat. The last thing I'll say is that all of this may be a moot point because there has also been widespread speculation that the Supreme Court will deny leave from the Quebec Court of Appeal to hear this case of Hack. Essentially, in the Hack decision, the Quebec Court of Appeal found that the fact that Quebec had invoked the notwithstanding clause offered a complete shield to any judicial review of substantive constitutional implications. And again, this is a court that has of late been quite deferential to Quebec. And so I personally, if I were a betting woman, my bet would be that the Supreme Court is going to deny leave in this case. Nonetheless, this has been an interesting little mini judicial scandal. What do you think, Josh? Do you think Jamal should have stood his ground and heard the case? Theoretical case?
I don't know. I would sort of lean toward that position because, on the one hand, you can see the perception of bias that he was the senior executive at the time when when they were deciding whether or not to get involved in this particular situation. So I can see those who would want him to recuse, but at the same time, like every judge is a former lawyer and they're going to have biases to some degree, right? Like, are we going to say someone that's a criminal defense lawyer can't sit on criminal cases just because they've always been on that particular side of the equation, or someone was a prosecutor and therefore they can't sit on criminal law cases? Like that makes up half of the court's docket, right? So we would never do that. So the standard for recusal should be quite high, and there should be, some really significant degree of involvement, I think, before we start talking about forcing people to recuse.
So I think that there's some optics issues, right? Like this is a case that was brought from, as a Muslim, it was Muslim complainants, I think, who brought this case. And I mean, of various religious minorities. And Justice Jamal is, I think, one of the only religious minorities on the court. He's Ismaili Muslim, converted to Baha'i later in life. So I do think that the optics of one of the only, or if perhaps the only religious minority judge having to recuse is not great. I think that that's an important perspective. On the other hand, I don't know that I agree with you that there's an analogy, Josh, between someone who practiced criminal law and someone who was on the board of a charity that brought the case. So I do think that, if depending on what the governance structure of the CCLA is like, he may or may not have had some involvement in the decision to bring the case. And I think that that's different from just the general practice of criminal law. I don't know how their charity is structured, so I don't know how much involvement he had. But I do think that because he was at that level of involvement, unless he could explain why he wasn't involved in the case, that it definitely creates, at a minimum, the appearance of a conflict. And judges, I think, should take precautions to avoid the appearance of a conflict in order to uphold the integrity of the system. I think one of the other questions I have is someone else going to recuse themselves in order for the court to be balanced? And if so, who would that be? So that's it. That's sort of my reaction. It's certainly interesting. And I don't know my take on whether or not they'll grant leave. I think if I were to bet, I would bet against granting leave, unfortunately, because I think that this is such an important case and it's such an important issue that needs judicial determination. But I've been disappointed.
But they could grant leave and then only opine on the Section 33 stuff, which I guess would be interesting in its own right.
But if they wanted to do that, they could take the Saskatchewan case.
Right.
Anyway, let's move to our bad legal takes. I can go first. My bad legal take goes to Brittlestar, who is a Canadian online, and I will use the quotation marks, comedian. And I think that is a very loose definition of comedian. So last week he made a video about the LCBO strike in Ontario. For those of you listening who don't live in Ontario, we are forced to buy most of our alcohol, although not all now, but most of it through a government store called the LCBO, the Liquor Control Board of Ontario. And the Ford government is seeking to expand alcohol sales beyond this mostly government monopoly. And the LCBO workers are now on strike. And the strike is really less about workers' rights and wages than it is about the union objecting to anyone besides them being allowed to sell this basic product. So now that the LCBO workers are on strike, it has raised some general questions about why we even have this archaic and stupid system where we buy alcohol from the government. Uh, but they already sort of lost some of their monopoly power. So the strike isn't as powerful as it would have been if they had a monopoly, because we can buy some alcohol in grocery stores and other like wine rack stores. And the government actually released an interactive map where you can find alcohol at non-LCBO stores. So now enter Brittlestar. So there is this weird phenomenon in Canada where boomers act as sycophants to the government in their spare time. And Brittlestar is like the best example of this. And he says it's comedy, but really it's just like making progressive government propaganda as a hobby. And it is probably the worst hobby that you can have. I don't get it at all. And I don't get why anyone thinks it's funny. So he made this funny video in support of the LCBO, and even weirder, it was like ostensibly aimed at kids. It was with, rainbows and all these colorful little sing-song music video about educating us about why the government monopoly is actually so good, because when you buy beer from the government, it pays for our roads and healthcare. Now, setting aside that most of us think our roads and healthcare is pretty bad, so that's not a convincing argument. The argument is still stupid. Even if the roads and healthcare was good, this is still a bad argument. You could make this argument about nationalizing just about any industry, like grocery stores or clothing, banking, energy. Like, this is insane. Like, yeah, you can get government revenue by nationalizing things. That doesn't mean it's a good idea. It doesn't mean that's the best way for that product.
Also, the standard way to do this, just to briefly interject, is to just tax these things, not to entirely make it a state-run store. Like, there's a middle position. Yeah.
So I guess that the bad legal take is saying that the government should have a monopoly on these services, that this is a good policy. And there's a related bad legal take, because there's some people who have been saying Brittlestar's cringy video is third-party political advertising. It's not. It's just really stupid. It's a stupid policy. It's a stupid defense of the policy. And then that's another stupid bad legal take in response to his stupid bad video. Okay. Josh, how about you? What's your bad legal take this week? And did you watch the Brittlestar video?
Oh, I watched a few seconds of it, and then it made me feel nauseous and reminded me of that time where Colbert had, dedicated his comedy to the vaccine. Do you remember that? Where they had like
I did not watch any of that.
Dancing syringes, and it was supposed to be funny.
Yes, I do remember.
The best is watch when Jon Stewart goes on Colbert and starts raising questions about the lab leak, and Colbert just looks absolutely like he's about to pass out. I remember that. That is brilliant, and that should
cut him off.
Yeah, exactly. He was just like, "You crossed the Rubicon."
We're in weird times when Jon Stewart is like the voice of reason in society, but yeah. Don't
worry, he's gone back to being cringe.
Oh, I haven't watched. Okay, my bad legal take goes to, speaking of cringe, Justin Ling, freelance reporter and columnist, who I have lots of time for. I read all of his stuff, but this is yet another bad legal take in the Toronto Star. Surprise, surprise. Ling writes that, quote, queer rights are in danger in Canada and Poilievre is partly to blame. And, I didn't even know there was such thing as queer rights, because to me, queer has always just been sort of a political term that signals that you're of the more sort of militant, progressive viewpoint on LGBT issues. But I'm going to give him the benefit of the doubt and believe that maybe he just wants to use a shorter term than the current one, which is like 2SLGBTQIA++, whatever. Anyway, so Ling starts this piece by suggesting that rights are under threat because polling shows a declining number of people in Canada say they know someone who's LGBT, and the pollster calls this the visibility measurement. And that can only mean one thing: growing bigotry against LGBT people, and apparently not the fact that, Canada's demographically changing and there's a lot of immigrants from countries where they have different viewpoints on LGBT stuff. And Ling says what's obviously happening here is that conservatives are, quote, radicalizing their supporters. And he says this is going to lead to violence against LGBT and repeal of rights. And then he gets into what he means. And what he's saying is this new radicalizing by the conservatives is going to lead to blocking younger teens from accessing puberty blockers and gender reassignment surgeries, and preventing kids from using preferred pronouns or new names at schools without parental permission. And this hardly seems like a repeal of rights rather than, democratic line drawing about when people become mature enough to make these kinds of decisions, which in the case of, puberty blockers can have serious side effects, or surgery can be irreversible. And he really goes off the rails where he starts comparing Canadian politicians to Nazis in Germany. And basically, he points out that Hitler and Nazis targeted Magnus Hirschfeld, who did some of the earliest gender reassignment surgeries, what he calls gender confirmation procedures. And his evidence for this seems to be that Poilievre said in 2008 that Ontario Liberal Premier Dalton McGuinty shouldn't be funding sex change surgeries because, quote, federal health transfers should not go to, or should go only to vital healthcare treatments and not to the McGuinty sex change program. And so what makes this a bad legal take is the suggestion that, things like taxpayer-funded sex change surgeries or access by younger teens to hormone blockers is somehow violating human rights. I think all of us would agree, at least on this podcast, that, any adult should be able to make these kinds of decisions and be free from discrimination. And, kids who identify as LGBT should be treated with compassion and kindness. But that doesn't mean the state has to pay for or endorse every medical treatment for everyone at every age. And that's why I think this super hyperbolic piece is a bad legal take. So, Joanna, let's hear your BLT.
So I was deciding between a paper that Joshua Seeley Harrington wrote and this, and I have to bring up a bad legal take all-star, Heidi Matthews, who has been making the rounds in the maritime media in response to Memorial University decided to clear its pro-Palestine encampment after the U of T Ontario Superior Court injunction decision came out. And Memorial's rationale for this was that the legal principles around property ownership and control of property are equally applicable between Ontario and Newfoundland. And you'll recall from our extensive commentary on this issue that Justice Conan, the Ontario Superior Court, almost entirely perched his decision, allowing U of T the injunction on the principle of trespass law. That appropriating private property was unlawful, especially appropriating it to the exclusion of other people who wanted to use the space. The charter didn't apply, and that even the strongest, even if he was wrong, the strongest claim of a violation of charter expression could not override a trespass claim. And so Heidi Matthews took to the media saying that this is misleading. She said different provinces have different regulatory regimes governing the relationship between governments and universities, and a court in this province may well decide the question of charter application to campus differently than the Ontario court did in U of T. And Christine put it the best. This is so pedantic. Any lawyer worth their salt would tell you that litigating this issue, given the precedent of U of T, which, by the way, seems to have had an immediate ricochet effect to all Ontario universities, where obviously it clearly applies, but also as of this morning, McGill is dismantling its encampment. So it clearly has strong precedential weight, and Heidi knows this. So what really rankles me about this is it's in such bad faith. Under no circumstances, if you were the client, either the university or the students in Newfoundland, would you tell them that it was advisable to go ahead and litigate this issue when there's at least 95% probability that the court would side with the U of T precedent? So she's been going on and feigning outrage. And I just think it's unseemly. So that's my bad legal take of the week.
All right, so as usual, we hope you'll rate us, review us, and subscribe. And I just remembered now to mention that we are also going to ask listeners to do a survey, which you'll find in the show notes or under the video on YouTube. And we hope you'll support our work by subscribing to the CCF's YouTube channel, by following us on Twitter, or by visiting our website, theccf.ca, where you can sign up for our new and improved Freedom Update newsletter from our colleague Russ. The CCF is a nonpartisan legal charity funded by your donations, so please click that donate button on our website if you can. Thanks for listening.